The Republican senators bat down every concern. No Supreme Court nominee has been confirmed this close to a presidential election. They say, no problem. Republican senators plunge ahead with an illegitimate nomination made by a morally bankrupt president. The Rose Garden ceremony to celebrate the nomination turns into a coronavirus super spreader event. Republican senators brush it off. Republican senators will press ahead with hearings while members of the Judiciary Committee are in quarantine and some of them refuse to get tested. Hundreds of thousands of Americans are dead and millions are waiting for the federal government to finally show up and fight this pandemic. Republican senators say, sorry, no time. Senate Republicans have better things to do than pass a relief package, things like steal a Supreme Court seat. Here's the ugly truth. Donald Trump and his Republican buddies know that confirming Amy Coney Barrett to the nation's highest court is their path to advance an extremist agenda long after the country is fed up and disgusted with their failures. In the middle of an election, in the depths of a pandemic, their extremist agenda is all that matters. And that's why they are so desperate to ram her nomination through the Senate. The confirmation hearings were a sham. The conclusion was foregone, and the nominee spent days ducking and dodging legitimate questions about where she stands on issues of crucial importance to the American people. It was little more than a PR stunt. But what the nominee refused to say was actually very informative. She refused to say whether the ruling upholding the right to contraception was correct. She refused to say whether the government can criminalize a same-sex relationship. She refused to say whether it's wrong to separate children from their parents in order to deter immigration. She even refused to say whether climate change is happening and whether it poses a threat to human beings. This was no hearing. This was a farce. Barrett's attempt to remain silent on key issues spoke volumes. It shows that she believes these critical rights, protections, and values are debatable, up for grabs. And Barrett's refusal to embrace these common sense values shows just how out of step, how extreme Barrett is and will continue to be if she is confirmed. Let's be real. We already know what Barrett is all about. We know why corporate interests and right-wing zealots are so excited about her, why so many Republicans will vote to confirm her, and why Trump, who has handed the judiciary over to the Federalist Society, has nominated her. It is because she will advance their extremist conservative agenda. So her question dodging isn't a problem for them. It's part of their strategy to get her onto the court. They know where she stands, and so do the American people. We already know because her record is clear. Take reproductive rights. President Trump pledged to nominate Supreme Court justices who would overturn Roe. Listen to him. He said he would only appoint someone who would overturn Roe. And then he picked Barrett. In 2006, Barrett signed a newspaper ad calling for the end of Roe and describing Roe as barbaric. She was a member of an anti-choice group while on the University of Notre Dame faculty. And how will she overturn Roe? After all, Roe is the current law of the land. But Barrett has that all worked out. She holds a dangerously radical view on legal precedent. In a 2013 Law Review article, she suggested that the Supreme Court is not strictly bound by precedent and that public debate about Roe leaves open the possibility of overruling it. To state it plainly, Barrett believes women cannot be trusted to make decisions about their own bodies. She is a clear and present danger to Roe. When it comes to the Affordable Care Act, again, listen to Trump himself. He said he would only nominate judges who will end the ACA law, judges who would take away health care coverage from millions of Americans. He picked Barrett. Barrett's record indicates that's exactly what she will do, work to gut key provisions that protect millions of Americans. She criticized Chief Justice Roberts' opinion in 2012, upholding a critical part of the ACA, saying that he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute, close quote. In a media interview in 2015, she said that in another Supreme Court decision that upheld the ACA, the dissenting justices who wanted to overturn the ACA had the, quote, better of the legal argument. While claiming just to follow the text of the law, Barrett's record shows that her purported textualist approach is nothing but a facade, merely a cover for her to reach a result that will further the interests of those with money and power. Now, Barrett's record isn't just cringeworthy, it's downright alarming. On November 10th, just 1 week after Election Day, the Supreme Court will hear a case that will determine the fate of the Affordable Care Act. And right now, 17 cases that could undermine the right to abortion care are one step away from the Supreme Court. 21 states are ready to go. They have already drafted laws they can pass immediately, laws that could be used to restrict abortion in case Roe is overturned. And it's not just reproductive rights and access to health care that are on the line. Trump and his Republican enablers want a justice who will rubber stamp Trump's racist and xenophobic attacks on immigrants, from ripping away protections for our dreamers to rewriting the census. Once again, this is exactly what Donald Trump told us he would do after he lost earlier court cases. Trump and his Republican enablers also want a justice who will turn back the clock even more on workers' rights. Trump wants a justice who will erode workers' abilities to join together and fight for fair pay and working conditions and to push back against employment discrimination. We know this is what they want because those are the policies the Trump administration has pursued and what Barrett's anti-worker record tells us that she will do. And there's another thing about Barrett's record that deserves special attention just 8 days before the election. Trump and his Republican enablers want a justice who will strip away voting rights, especially from communities of color and marginalized communities. Trump wants a Supreme Court justice to help undermine our democracy. We know this because Trump already told us his game plan to do it. Trump and his Republican enablers are working to make voting as difficult, confusing, and scary as possible. And they're using every tool in order to do it. Trump has lied repeatedly about mail-in voting. He's falsely claimed that it's the source of rampant fraud. Trump's lawyers have sued states that have taken action to try to help Americans vote safely during this pandemic by expanding vote by mail. And at the same time, Trump and his cronies are working to dismantle the U.S. Postal Service, slowing down mail delivery and creating even more barriers to the ballot at a critical moment in this election. We've all seen the president's reckless, dangerous statements over the past few months, casting doubt on the election itself, peddling the fact-free claim that this election will be, quote, the most rigged, close quote, in American history, and that he is, quote, not sure, close quote, that the election results will be accurate. Most alarming of all, Trump has repeatedly refused to commit to a peaceful transfer of power, and he said that he will not accept the election results if he doesn't win. And as her confirmation hearing shows, Barrett is just the justice Donald Trump is looking for. In her hearing, Barrett refused to recuse herself in a case that might decide the outcome of the election. And she refused to say whether she believes that a president should commit to the peaceful transfer of power. She also refused to say whether voter intimidation is illegal, which it is, whether the president can unilaterally delay an election, which it cannot, and whether the Constitution empowers Congress to protect the right to vote, which it does. The stakes have never been higher for our democracy. On one issue after another, on one right after another, Trump and his Republican enablers have made it clear they want a court that will bend over backwards even further for the wealthy and well-connected while running roughshod over everyone else. They want a court that will keep them in power even when voters have had enough of their fear-mongering and division and graft. And Barrett is their choice to do just that. And that's why this vote is so critical. A vote for Barrett is a vote to strip health care from millions of people. It is a vote to turn back the clock on reproductive freedom, to endanger dreamers and immigrants, to let climate change rampage unchecked, to imperil efforts to address systemic racism, to place workers' rights, voting rights, LGBTQ rights, gun violence, prevention, all at risk. Ultimately, it's also a vote to rubber stamp an illegitimate process carried out against the wishes of much of the nation and against the backdrop of a deadly crisis that Senate Republicans have ignored as Americans have died. Let's be very clear. If Trump and Republicans succeed in ramming this nomination through, the American people will expect us to use every tool we have to undo the damage and restore the court's integrity. I'm under no illusions here. Democrats have fought tooth and nail, but the Republicans control the Senate. The reason the Republicans are willing to break every rule to jam through an illegitimate nomination 8 days before the election is that they have realized a truth that shakes them down to their core. The American people are not on their side. People all over this country are fighting to reclaim our democracy. They are registering to vote, and they are voting. They are voting like never before. They are speaking out and telling their stories. They are fighting for a democracy that works for all of us, not just for the privileged few. And they will continue to fight until they've taken our democracy back from those who have worked around the clock to undermine it. Now, I want to spend some time drilling down on what's at stake with this vote, starting with the impact that dismantling the Affordable Care Act will have on my constituents in Massachusetts. I will start with an op-ed that I wrote with Amy Rosenthal, the Executive Director of Healthcare for All, and Kate Walsh. She's the President and CEO of Boston Medical Center. It was published in the Boston Globe, and it was entitled, "The Affordable Care Act and Coverage for Massachusetts Residents is at Risk." Here's what we wrote. Dave was laid off from his hotel job in March due to the coronavirus pandemic, and he lost his health insurance too. A week later, he was rushed to the emergency room with a lung problem. With support from an enrollment assister, he was able to enroll in mass health coverage that was made possible because of the Affordable Care Act, better known as Obamacare. He is just one of the hundreds of thousands of Massachusetts residents given a lifeline by the ACA. Yet the multi-year effort to repeal the law is coming to a head at the worst possible time. Just days after the November election, the U.S. Supreme Court will hear oral arguments in a case seeking to overturn the ACA. And Supreme Court nominee Coney Barrett has a clear record on the issue. She has openly questioned the constitutionality of the ACA, arguing that the Supreme Court's ruling upholding the ACA's individual mandate was, quote, illegitimate. If she is confirmed to the court, she may provide the decisive vote to strike it down. For people like Dave and more than 23 million others nationwide, access to health care hangs in the balance. The need for health care coverage has never been more dire than during the COVID-19 pandemic. It has laid bare devastating racial disparities in healthcare access and outcomes. The ACA coverage expansions led to progress toward equity, with the gap between insurance coverage rate for Black and white adults dropping by 4 percentage points, and the difference between Hispanic and white adults falling by 9.4 points. Now, instead of building on these important steps, overturning the ACA would further exacerbate inequities in access to health care. The elimination of the ACA would also be devastating for people with specific health care needs, including 1.8 million people living with substance use disorders and mental illness. Protections would also be stripped away from 135 million people who have pre-existing conditions like diabetes, cancer, asthma, and those now who have had COVID-19. Insurance companies could once again charge women 50% more than men for coverage and impose lifetime caps on benefits. It would strip a popular feature for families, coverage for those up to age 26 who have sought coverage on their parents' plans at a time when youth unemployment has doubled due to COVID-19. In Massachusetts, where our state's health reform law served as a model for the ACA, many falsely believed that we would be protected if the ACA were struck down. This is not the case. Thanks to the ACA, a number of new protections were implemented in the Commonwealth. The provision allowing young people to stay on their parents' plan, and the reduction of prescription drug costs for seniors caught in the Medicare donut hole. These protections could be gone overnight if the ACA were invalidated. In addition, an ACA repeal would impact access to health coverage and health care for hundreds of thousands of Massachusetts consumers. The state's health insurance coverage expansions were only possible with the partnership and funding from the federal government. This is especially true for the expansion of Mass Health, our Medicaid program, as well as the availability of affordable coverage through Connector Care. Over 375,000 Massachusetts residents could lose their health coverage, and the state stands to lose up to $2.4 billion in federal funds. These immense cuts would create a funding gap that would be impossible to fill even during normal times. The challenge is even greater now. According to some estimates, Massachusetts may face a deficit of up to $6 billion as a result of the pandemic. These funding shortfalls could have devastating implications for the healthcare safety net in Massachusetts. Taking coverage away from people during the worst pandemic we have experienced in the last century is simply despicable. and we should all be outraged. Massachusetts deserves more from its president and from its government. All of us must speak up, speak out, and make it abundantly clear that the ACA cannot be repealed. Speaking up includes speaking up about how the ACA has transformed people's lives. And so many folks in Massachusetts reached out to my office to share their stories and how they would be harmed if health care were ripped away. So I want to introduce you to a few of those people. Thank you. Marlene, Deb, and Charlie. Marlene is a single mom from Framingham. She receives her health care through Connector Care, the plans we have in Massachusetts for low-income families who don't qualify for any other program. Her children use Mass Health Family Assistance, which is our CHIP program. She says that without the help she gets from Mass Health and from Connector Care, she couldn't pay her rent and bring food to the table for her kids. You know, the Affordable Care Act helped Massachusetts expand Medicaid and more affordable insurance plans like the ones Marlene uses. But if Trump's Supreme Court nominee overturns the ACA, Massachusetts could lose $2.4 billion in federal funding. Over 375,000 people, like Marlene and her children, could lose their coverage. Deb from Greenfield knows what it's like not to be able to pay for health care. She told me, quote, "I was an American whom Obamacare saved at the very moment I lost my career and my health." She writes, "You must step in and take action. We cannot sit idly by while our access to affordable health care hangs in the balance." Deb is right. And there are millions of people across this country who have lost their jobs during this pandemic and economic crisis and could be in the exact same position that Deb was in. And finally, I checked back in with my friend Charlie and her mom Rebecca, who live in Revere. Charlie and I fought side by side at the Capitol during the healthcare fights in 2017. Her mom reminded me about that. She said, due to severe preeclampsia, Charlie was delivered at 26 weeks gestation and weighed 790 grams. That's about 1 pound, 12 ounces. She was in the NICU for 3 months. Without the ACA, she would have exceeded a lifetime cap before ever coming home from the hospital. Additionally, she would have been uninsurable because her birth was a pre-existing condition. With access to health care, Charlie was able to thrive despite some pretty significant diagnoses. And now, at the age of 8, Charlie lives a very much typical life. Repealing the Affordable Care Act now would be devastating for Rebecca and Charlie. They can't go back to lifetime caps or sky-high rates and denied coverage because of pre-existing conditions. None of these families can. And like so many policies, Black and brown communities will be disproportionately affected if the ACA is destroyed. I want to read another op-ed I wrote recently that was published in Shondaland. It discusses the harm of stripping away health care for communities of color. And here's what it says. Over 10 years ago, President Barack Obama signed the Patient Protection and Affordable Care Act, ACA, into law. Since then, we've made progress. Millions of Americans now have high-quality, affordable health insurance. We no longer have to worry about being denied coverage because of pre-existing conditions. Millions of young adults can stay on their parents' plans until age 26. States were given the option to expand Medicaid eligibility, providing coverage to more than 12 million low-income Americans. But now the ACA is at risk because Republicans are trying to ram through Amy Coney Barrett's nomination to serve as the next Associate Justice of the Supreme Court. They are trying to push her confirmation through at breakneck speed because just 1 week after the November elections, a case to overturn the ACA will be in front of the Supreme Court. And Republicans want Barrett to have their back, to cast the deciding vote, and to deliver a death blow to the law. Republicans have railed against the ACA from the day it was passed, making its repeal a tenet of their platform in every presidential and congressional race. They've tried dozens and dozens of times to tear it down piece by piece, all while ignoring the plethora of data that demonstrates the good it has done for the American people. Among the chorus of ACA detractors is Judge Barrett. While she tried to claim during her Supreme Court hearing that she's, quote, not hostile to the ACA, her record says otherwise. She criticized Chief Justice Roberts' vote in 2012 to uphold the ACA and wrote reviews questioning the law's constitutionality. Her nomination is just the latest Republican attack on the ACA. And if she is confirmed, Mitch McConnell and Donald Trump might get their wish and succeed in ripping health care away from tens of millions of people during a global pandemic. And here's what that would mean. In the middle of the COVID-19 crisis, insurance companies would instantly be able to enforce caps on coverage or deny coverage to the 133 million Americans with pre-existing conditions like asthma, diabetes, even pregnancy. COVID-19 itself could be considered a pre-existing condition for the millions of Americans who have survived the virus. The 12 million low-income Americans now covered by Medicaid expansions would lose their coverage, including more than 850,000 Americans struggling with opioid use disorder, people who rely on Medicaid for life-saving medication, assisted treatment, and counseling services. Millions of young adults would be thrown off their parents' insurance, forcing them to pay out of their own pockets, even as many struggle under a mountain of student loan debt, stagnant wages, and high unemployment rates due to the pandemic. And the damage won't stop there. Repeal of the ACA would have devastating consequences for Black and brown communities that disproportionately benefit from its coverage. The ACA helped narrow disparities in access to health care in the United States and provided millions of Black and brown families affordable options for care. Without the ACA, 1 in every 5 Black Americans and 1 in 3 Hispanic Americans would be uninsured. If the ACA is dismantled, Black and brown communities that benefit from Medicaid expansions would be kicked off their insurance. In the midst of a maternal mortality crisis that disproportionately impacts mothers of color, moms across this country could lose access to the well-woman visits and the maternity coverage currently required by the ACA. So let's call out this Supreme Court nomination for what it is. Donald Trump and the entire Republican Party's big chance to compete and complete a decade-long partisan attack on the ACA and on Americans' rights to health care. It's the big chance for a desperate party to impose its extreme views on the people of this country because they couldn't actually get it done through Congress. The majority of Americans want the Senate to wait until after the election to choose a new justice. It's because this is a life or death situation for their friends, their families, and for millions, tens of millions of their fellow Americans. In 2012, after yet another attack on the ACA was defeated in the Supreme Court, Justice Ginsburg wrote that, quote, "The crisis created by the large number of U.S. residents who lack health insurance is one of national dimension," close quote. And she cited, quote, "the inevitable yet unpredictable need for medical care," close quote, as a reason to uphold the legislation. Justice Ginsburg was right. Healthcare is a basic human right. We fight for basic human rights. We fight against this nomination, and we fight any attempt to rip away health care from families. We do this together. It's not just health care for tens of millions of people that's on the line. A woman's right to make her own health care decisions is also in jeopardy. Roe v. Wade is a landmark case that protects a woman's right to abortion care. A few weeks ago, I published an op-ed in The Cut that discusses what this nomination means for the right to abortion care, and I want to read it now for you. This is what I wrote, quote, "The decision whether or not to bear a child is central to a woman's life, to her dignity. It is a decision she must make for herself. When government controls that decision for her, she is being treated as less than a fully adult human responsible for her own choices," end quote. Justice Ruth Bader Ginsburg said that 30 years ago at her Supreme Court confirmation hearing. She understood that reproductive freedom is foundational to equality and critical to women's health and to their economic security. Without access to high-quality reproductive health care, including contraception and safe legal abortion, we cannot have true equality. But President Trump, Senate Republicans, and their extremist allies just don't care. They've spent almost 4 years of the Trump administration, and many years before that, undermining health care and turning back the clock on reproductive rights. And that is why they have nominated Amy Coney Barrett to sit on the Supreme Court. She's the ticket for a desperate right-wing party that wants to hold on to power a little longer in order to impose its extremist agenda on the entire country. President Trump and his Republican enablers have tried to deny this obvious fact. The president recently said that he didn't know how Barrett would rule on reproductive rights, and Republicans in Senate have fallen in line. The Republican Party knows the large majority of Americans do not support overturning Roe v. Wade. They benefit when we stay on the sidelines, and they want us to sit back and stay quiet while our fundamental freedoms are on the line. But we see right through their radical play. President Trump picked Barrett as his Supreme Court nominee to take us back in time. Roe v. Wade established the constitutional right to safe and legal abortion and has been the law of the land for over 47 years. But over and over and over again, President Trump has bragged about his plans to appoint justices who would, quote, automatically, close quote, overturn Roe. The Affordable Care Act expanded access to reproductive health care, like no copay birth control, for millions of people. But President Trump has promised to overturn the Affordable Care Act in its entirety and sent his Justice Department to ask the Supreme Court to do exactly that. Barrett is Trump's ideal candidate to accomplish his plans. In 2016, she signed a newspaper ad calling for the end of Roe and describing the decision as barbaric. She was a member of an anti-choice group while on the University of Notre Dame faculty. She was also critical of the Affordable Care Act and the Supreme Court's past decision to uphold the law in court. Her position on abortion and other reproductive rights are clear. She believes women cannot be trusted to make decisions about their own bodies. If Barrett's nomination makes you scared and angry, you are right to be. 17 abortion-related cases are already one step away from the Supreme Court. 21 states have laws that could be used to restrict abortion in the case that Roe is overturned. And if Barrett's confirmation is rammed through quickly, she'll have the opportunity on November 10th to hear a case about overturning the Affordable Care Act and a lifetime on the nation's highest court to undermine the rights and the values that we hold dear. Access to birth control has changed the economic futures of millions of women, and access to safe abortion care is an economic issue too. For a young couple with modest wages and piles of student loan debt, the decision to start or expand a family is a powerful economic one. For a woman working 2 jobs with 2 kids already in daycare, an unplanned pregnancy can upend budgets already stretched too far. For a student still in high school or working toward a college degree, it can derail the most careful plans for financial independence. Indeed, one of the most common reasons that women decide to have an abortion is because they cannot afford to raise a child. And let's be explicitly clear. If these attacks succeed, they will have disproportionately negative consequences for women of color, who are already facing some of the most insurmountable barriers to abortion care. Rich women will still have access to abortion and reproductive care, but it will be Black and brown women, women with low incomes, women who can't afford to take time off from work, and young women who were raped or molested by a family member who will be the most vulnerable. This is not a moment to back down. Already, it is inspiring to see so many women and friends of women coming off the sidelines in this fight, and we must continue to speak up. Call your senators and make sure this conversation is grounded in our real experiences. Men must speak up too, because reproductive freedom affects us all. Voting is already underway across the country, and there are only 26 days before the election is completed. And the data show that most Americans want to wait until after the election for a new justice to be confirmed. Justice Ginsburg gave us our marching orders: do not fill this Supreme Court seat until after the election, when the next president is installed. We will fight hard together to honor her wish. There are countless powerful stories that demonstrate why abortion rights are so important, and I'm going to read a few of them. The first is from my friend and colleague from Michigan, Senator Peters, who became the first sitting U.S. Senator to share his abortion story. I'll just read an excerpt of that powerful piece that was published in Elle magazine. In the late 1980s in Detroit, Peters and his then wife, Heidi, were pregnant with their second child, a baby they very much wanted. Heidi was 4 months along when her water broke, leaving the fetus without amniotic fluid, a condition it could not possibly survive. The doctor told the Peters to go home and wait for a miscarriage to happen naturally, but it didn't happen. They went back to the hospital the next day, and the doctor detected a faint heartbeat. He recommended an abortion because the fetus still had no chance of survival. But it wasn't an option due to a hospital policy banning the procedure. So we sent the couple home again to wait for a miscarriage. The mental anguish someone goes through is intense, Peters says, trying to have a miscarriage for a child that was wanted. As they waited, Heidi's health deteriorated. When she returned to the hospital on the third day, after another night without a natural miscarriage, the doctor told her the situation was dire. She could lose her uterus in a matter of hours if she wasn't able to have an abortion. And if she became septic from the uterine infection, she could die. The doctor appealed to the hospital's board for an exception to their anti-abortion policy and was denied. I still vividly remember he left a message on the answering machine saying, "They refused to give me permission, not based on good medical practice, simply based on politics. I recommend you immediately find another physician who can do this procedure quickly," Peters recalls. The Peters were able to get into another hospital right away because they were friends with its chief administrator. Heidi was rushed to an emergency abortion that saved her uterus and possibly her life. The whole experience was painful and traumatic, Heidi shared in a statement. "If it weren't for urgent and critical medical care, I could have lost my life." Reflecting on the experience now, Senator Peters says it, quote, enacted an incredible emotional toll, close quote. So why go public with it? Well, it's important for folks to understand that these things happen to folks every day, he explains. "I've always considered myself pro-choice and believe women should be able to make these decisions themselves. But when you live it in real life, you realize the significant impact it can have on a family." Peters decided to share the story at this moment because the right to make such decisions as a family, free of politics, has never been more at stake. He is alarmed by the threat of Donald Trump's Supreme Court nominee, Amy Coney Barrett, the threat she poses to women's reproductive rights. The very conservative nominee once signed her name onto a newspaper ad calling Roe v. Wade, the landmark decision that legalized abortion, barbaric. If Republicans successfully confirm her to fill Ruth Bader Ginsburg's seat, she could reverse legal abortion in America or significantly curtail it. It's important for folks who are willing to tell these stories to tell them, especially now, Peters says. The new Supreme Court nominee could make a decision that will have major ramifications for reproductive health care for women for decades to come. This is a pivotal moment for reproductive freedom. Senator Peters is right. This is a pivotal moment for reproductive freedom. I've heard from so many of my constituents about the importance of Roe and reproductive freedom. I'm just going to share two of their stories. The first is from Kate, who lives in Medford, Massachusetts. Here's what Kate wrote. "Most of my life, my strong support for abortion was as impersonal as it was important. A late bloomer, I barely dated until I was in my 20s, then quickly met and married my wonderful husband. Our birth control always worked perfectly. Anyway, we are both family-minded and dreamed of building a family big with lots of kids. My husband and I had one daughter, planned and loved. But the second child was not so easy. I suffered 3 miscarriages in 2 years before a baby finally stuck. Pregnancy brought months of crushing nausea, but the sicker I felt, the better. The doctor said things must be going well. Healthy, 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 they told me, time after time. By late May, the end was in sight. Big and ripe and swollen, I bundled myself into the hospital for an ultrasound. I brought a tiny sweater to knit while I waited. After an hour of examination, the doctor entered the dark room. She saw the sweater and asked, "Is it for the baby?" I nodded proudly and showed her how all the pieces would line up just so to fit my newborn daughter. A month was plenty long to finish such a small project. "It's beautiful," she told me, her eyes filling with tears. Then she turned the monitor toward me so that I could see the big black fluid-filled holes in my baby's brain. There was so little that I knew that day. I didn't know about Dandy Walker malformation or the corpus callosum. I knew love. I knew fear. I knew my values. And I knew that I was in Boston, medical mecca, hub of the universe. I learned more about brains in general and my baby's brain in particular. MRI revealed poor prognosis. My daughter would not likely ever walk, talk, support the weight of her own head, or swallow. I learned that infant hospice was out of the question and that I could not refuse a feeding tube for my baby. Dumbfounded, I asked the neurologist, "What does a baby like mine do? Just sleep all day?" He winced. "Babies like yours," he explained, "are not often comfortable enough to sleep." I knew what I needed to do. 35 weeks pregnant, and I was afraid even to tell my husband, my mother, my doctor, my genetic counselor. But I talked to my family and I called the hospital. It was a Friday afternoon. My doctor was busy delivering triplets. I left a message. "I want to know all my options," I said, "all of them." She called me back at 6:30 p.m. and talked fast. She gave me the number of an adoption agency in upstate New York that specializes in medically complex children. "I'm so sorry," she said, "but if you want an abortion, you have to decide right away. You have to call before the end of the workday Mountain Time. You have to be on an airplane Monday. You have to show up Tuesday with $25,000 up front. I am so sorry," she said again. I did not have $25,000. I didn't know if the number led to a safe, legal doctor or if it led to some back alley quack. I only knew my desperation. I called the number right away. The woman on the phone was very kind. She too apologized. But Dr. Hearn does not practice after 36 weeks, and you'll be 36 weeks on the last day of your procedure. "Yes, of course," I said. "I understand. We'll be there. We'll find the money." And we did. There wasn't one day of open banking before our trip, so a loan was out of the question. We had to rely on my family. They were able to increase their credit while we flew across the country and withdrew the funds from their retirement account to cover the bill later in the month. Without them, I don't know what would have happened. I know now about abortion funds, but just as I didn't risk asking if what I was doing was safe and legal, I didn't want to ask for financial help. Everything felt so fragile. I met Dr. Hearn and his excellent team with great relief. They explained the procedure. My third trimester abortion was humane, gentle, safe, safer even in the 36th week than full-term live birth. We laid my daughter to rest in my womb that first day, a Tuesday. Friday morning, after brief labor, I delivered her whole and still into the hands of my Savior. He brought her to me after. She was still warm, but not quite warm enough. Dr. Hearn saved my daughter from immeasurable suffering. He saved my family from having to go against our deepest held values. Dr. Hearn saved me from my own desperation. And every step of the way, he saved my dignity. I want to share one more story. This one is from Wendy in Greenfield, Massachusetts. I'll just read a part of what Wendy wrote. She said, "I know firsthand that overturning Roe, whether overtly or by chipping away at access to abortion until Roe becomes meaningless, will not stop women from seeking abortions. It will, however, deny women access to safe abortions. Abortion has been with us since women have been getting pregnant, and it will continue to be with us no matter what the politicians and judges decide. In 1961, I was 17 and abortion was not yet legal, but I was pregnant and did not want to be. I was fortunate because I was able to tell my parents and they helped me find a doctor. But finding a safe, compassionate doctor turned out to be a different story. We knew an illegal abortion could be expensive and my parents didn't have much money. So we made a plan together that I would go by myself in the hopes that he would take mercy on me and charge me less. I know there were many heroic doctors who helped women back then at great risk to themselves. But this doctor, who I'm sure had seen other young women who were alone and without support, thought he could take advantage instead. I remember finding this somewhat run-down building and walking up a dark flight of stairs to his office. There was nobody there, just the two of us. And the office was untidy and dimly lit with the window blinds down. And the doctor himself appeared unkempt and unprofessional. His clothes were rumpled, he sat too close to me, and he put his hand on my knee and said, "We don't have to use the word abortion, dear." I knew immediately that I did not want this man to touch me, let alone perform an abortion. So I did what many young women in my situation back then weren't able to do. I walked out. I went back down that flight of stairs and out into the light of the street. I felt and still feel it was a narrow escape. So we found a second doctor. And in fact, this time it was my younger sister who had a guitar teacher who knew someone, because that's how it worked back then. And this time my mother came with me. We had to go at night to the back door, and though there was no nurse or assistant, this office was clean and it looked like a real medical office. And the doctor looked like a real doctor, but he was not a compassionate man. As I lay there on the exam table with my mother in the next room, the doctor lectured me the whole time, telling me I was a sinner, that the abortion was the wages of sin, and that he hoped I would learn my lesson. And he threatened that if I made noise, he would stop the procedure. I would have to have the baby, and everyone would, quote, know my shame. Although my experience was scary and humiliating, my story is not as horrific as many from that time. I survived without injury, as many women did not. But that's because I was lucky. I was lucky to have supportive parents. I was lucky they could afford to pay. I was lucky to have a precocious sister. And I was lucky her guitar teacher had contacts, and lucky he knew of a medically competent doctor. But nobody should have to depend on luck to get a safe abortion. Although that doctor tried to shame me, I am not ashamed. I don't think abortion is shameful, and I have never had a moment's regret. My abortion allowed me to live the life I wanted and to become a parent when I was ready to raise a child properly and responsibly. This was good for me and my life, but it is also a social and public health good. Abortion is a necessary part of family planning and women's health care, and denying or restricting access to it means that women cannot safely control their reproduction and therefore can't really control their lives, which means they can't participate fully and equally in society. It is bad social policy to hobble half of the population. Women of my generation already know what pain and hardship results from abortion bans, but younger women have grown up taking abortion access for granted as a right. And I urge them to speak out and tell their stories. And not only women, but men other family members, friends who have been involved and who have been affected. Bring up your experiences in conversation, contact your legislators and tell them they will be the ones in immediate danger whose lives and whose family lives will be affected. Senator Peter's story, Kate's story, Wendy's story is just about how gut-wrenching these decisions are. These are personal decisions that women should make for themselves. The Senate has no business taking up a vote on a Supreme Court justice who is already committed to take away health care from millions of people and to take away Roe versus Wade and its protection from millions of women. We may not have the votes to stop them, but that does not change the fact that what the Senate Republicans are doing is wrong. We will continue to fight it. We will fight it now in the Senate, and we will fight it come Election Day, November 3rd. I yield the floor.
Madam President.
Senator from Nevada.
Thank you. Madam President, I rise today to join my colleagues in opposing the confirmation of Judge Amy Coney Barrett as Justice of the Supreme Court. This is the wrong time to be choosing a Supreme Court justice, and Justice Barrett is the wrong candidate for a seat on that court. The timing of tonight's confirmation vote is shocking. The majority of Americans want to be able to weigh in on who should sit in Justice Ruth Bader Ginsburg's seat on the highest court in the land. They want to vote to choose a president to fill that vacancy. We are 8 days away from Americans casting the final votes in the 2020 election. Over 58 million Americans have already voted, including more than 649,000 Nevadans. The American people are making their voices heard in response to this administration's disastrous handling of the coronavirus pandemic, which has led to the loss of 225,000 American lives, including 1,748 Nevadans, and sickened over 95,000 Nevadans. In the middle of this crisis, Congress should be doing everything it can to address the needs of the American people. Instead, the Senate Majority Leader is ramming through a nominee at breakneck pace. He and the President are rushing this nominee's confirmation for a reason, because they believe, based on Judge Barrett's own public statements, that she will be the decisive vote to overturn the Affordable Care Act in a case that will be heard just a week after the election. On November 10th, the Supreme Court will listen to arguments from lawyers in a court case about whether the Affordable Care Act is constitutional. Majority Leader McConnell and the President want a justice who shares their views on the Affordable Care Act seated on the court by that date. Amy Coney Barrett's record on the ACA, not to mention her stance on the rights for women and LGBTQ Americans that you've heard from my colleagues today and you will hear throughout the night. But her record on the ACA poses tremendous risk to Nevadans at a time when they need every help we can extend to them during this health pandemic. That's why I opposed her nomination to the 7th Circuit Court of Appeals back in 2017. And that's why I oppose her confirmation to the Supreme Court today. Instead of rushing her through in a partisan fashion to a lifetime seat on the Supreme Court, we should be working together to get the additional coronavirus relief that Nevadans and Americans so badly need right now. Most of us here in the Senate understand that the American people need help to cope with the pandemic, to save lives and to stop the spread of the virus. People have to wear masks. They wash their hands and they socially distance. That's meant that businesses haven't been able to operate as usual. Some companies have been able to rethink their business models and thrive, but others just can't substitute online interactions for in-person contact. That includes Nevada's world-class travel, tourism, and hospitality industry. During April, Nevada had the highest unemployment rate ever recorded anywhere in the country at 30%. We're recovering from that peak more slowly than other states, and we still have one of the highest unemployment rates in the country. In August, second only to Hawaii's, it was 12.6%. Nevadans are hurting. Nevadans are hurting, Americans are hurting. My constituents tell me about it all the time, and the data is clear, what I see in Nevada. 1 in 7 Nevadans say they aren't getting enough to eat. And 1 in 5 Nevadans say the children in their household are underfed. There's been a 14% increase in those receiving SNAP benefits in the Silver State since February. 14% of Nevadans say they are behind on rent or mortgage, and 38% are having difficulty with household expenses. 110,000 households in my home state could be at risk of eviction by January. That's why I have spent weeks calling on Leader McConnell to extend and expand upon the support that we put in place in the relief legislation that we passed in the first half of this year. Unfortunately, instead of negotiating another COVID relief package, Leader McConnell would rather play politics. Nevadans need to understand the partisan political games that are being played right now. Over the last 7 months, Senator McConnell has refused to come to the table to even negotiate with the administration, with Speaker Pelosi and Leader Schumer. Now, Speaker Pelosi and Minority Leader Schumer originally asked for $3.4 trillion in a new stimulus package. They've since come down to a request for $2.2 trillion in relief. That's a decrease of $1 trillion from their original position. And in return, as they've been negotiating with the administration, President Trump and Secretary Mnuchin have offered $1.8 trillion in coronavirus relief. Clearly, Speaker Pelosi and Secretary Mnuchin have been working to get closer to an agreement over the amount and structure of the next needed comprehensive COVID relief stimulus package. Meanwhile, while that negotiation is going on, Senator McConnell's not even at the table. He refuses to even negotiate with the Democrats. Just last week, he has forced 2 votes on the floor of the Senate on relief packages that were crafted behind closed doors with no bipartisan negotiation. And the second package was half the price of the one before. That's not a negotiation. That's politics. Senator McConnell doesn't want a deal. He hasn't participated in the talks, and he's proposing less than a third of what even the Secretary of the Treasury thinks we need. Instead, the majority leader has been laser focused on one thing and one thing only: rushing through the Supreme Court nomination for Judge Amy Coney Barrett. There's a reason he is pushing so hard. He and others in the GOP have been obsessed with getting rid of the Affordable Care Act since it passed. And in Amy Coney Barrett, they see their chance to finally do just that. Now, I want Nevadans to understand exactly what's at stake and how we got here. Let me lay out the timeline of just some of the dozens of Republican attacks on the Affordable Care Act and how Judge Barrett fits into their larger plan to overturn health care protections. In 2010, the Obama administration passed the Patient Protection and Affordable Care Act, the ACA, to bring down health care costs and make sure that Americans had access to quality health care. Now, Republicans have been trying to repeal it ever since, voting at least 70 times to undo the law in Congress. And when they fail in Congress, they attempt it in the courts. Republicans have repeatedly used the courts to challenge Congress's power to enact the ACA. Their first attempt ended in failure in 2012, when the United States Supreme Court upheld the important provisions of the ACA in an opinion written by Chief Justice Roberts in the landmark case NFIB versus Sebelius. But that has not stopped the Republican leadership, even though a majority of the American people have made it clear over and over that they want the ACA and its extensive protections for health care. This administration and Mitch McConnell have been stacking the court with federal judges they believe would overturn the ACA. And Professor Barrett fits their profile. In 2017, Professor Amy Coney Barrett wrote a book review article for Notre Dame Law School, making it clear at the time in that book review that she thought Justice Roberts incorrectly decided NFIB versus Sebelius. She said that Chief Justice John Roberts, and I quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. And conservatives who agreed with her, well, they took notice, because in May of that same year, in 2017, they nominated her to serve as a judge on the Seventh Circuit Court of Appeals, go from a professor to a judge of the Seventh Circuit Court of Appeals. Now, while her nomination was pending in 2017, in July, the Republican leaders in the Senate again tried to force a vote to repeal the Affordable Care Act. And during that vote, the late Senator John McCain gave his famous thumbs down to show that he would not be responsible for repealing the ACA and ripping health care away from millions of Americans. Well, a couple months later, October 2017, Amy Coney Barrett was appointed to the Seventh Circuit Court of Appeals. I opposed her then for the same reasons that I oppose her nomination today. 1 month later, in November, she is then placed on President Trump's list of potential nominees to the United States Supreme Court. She just got to the Circuit Court. A month later, she's now on President Trump's list. And why is she on that list? Because she made it very clear in her writings that she was opposed to the Affordable Care Act. And then 3 months later, in December of 2017, the Republicans in Congress passed a bill that would continue their attempts to sabotage the ACA. What they couldn't get done, because Senator John McCain and several others stopped him, they continued to sabotage it. So they passed a law. And based on this new law, several Republican attorneys general then went to court asking the court to rule the ACA unconstitutional. That case is California versus Texas. And it will be argued this year, November 10th, just 2 weeks from now. So their pathway has been consistent. I give them credit for that. The Republicans have been consistent in wanting to do away with the Affordable Care Act. They've either tried it here in Congress or they're continuing to work the courts. And if they can't win in courts, then let's put judges on the federal benches that we know will support our position. And that's what you have happening. That's why this is being rushed through now, because they need Amy Coney Barrett on the bench when that case is heard November 10th to determine the constitutionality of the Affordable Care Act. And let me tell you, the U.S. Department of Justice has done everything it can to assist their efforts to strike down the ACA. They filed a brief. The U.S. Department of Justice, on behalf of the Department of Administration, President Trump's administration, have filed a brief arguing that the entire law is invalid in support of those Republican attorneys general who want to do away with the Affordable Care Act. They've done this because the president wants them to. In an interview with 60 Minutes that aired just this evening, the president said that with regard to the Supreme Court's decision on the Affordable Care Act, quote, "I hope that they end it." And that's not the only time. It's not a secret. President Trump wants to do away with health care coverage and patient protections in the middle of a pandemic that has killed 225,000 Americans. And he's been very clear about it. I mean, look back, June 26, 2015. If I win the presidency when he was a candidate, my judicial appointments will do the right thing, unlike Bush's appointee John Roberts on Obamacare. February 8th, 2016. I'm disappointed. This is President Trump. I am disappointed in Chief Justice Roberts because he gave us Obamacare. He had 2 chances to end Obamacare, and he should have ended it by every single measurement, and he didn't do it. So that was a disappointing one. May 7th, 2020. President Trump reiterated his position. We want to terminate health care under Obamacare, and Obamacare is a disaster. September 27th, 2020. Shortly after Barrett's nomination to the Supreme Court, President Trump tweeted, Obamacare will be replaced with a much better and far cheaper alternative if it is terminated in the Supreme Court. Would be a big win for the USA. So 4 years, at least while I've been here, Republicans have been trying to repeal it, and this administration has been promising a replacement for health care in this country if the Affordable Care Act is repealed, but we see no replacement. And we know that they've been putting judges on the federal courts that will do their bidding, or at least think that they will do their bidding. Now, let me give Judge Amy Coney Barrett credit, because here's the thing. As an attorney, I respect judges. And I'm always looking for a judge, a mainstream judge, who is going to weigh the evidence and the facts, look at the precedent, and make a decision that is on behalf of this country and the American people. So it is fair, though, without knowing her background, to judge which way she is going to rule if she has an inherent bias based on her writings. That's what we do all the time. What are her writings, whether it is in private life as a professor or as an attorney practicing law or as a judge in her written opinions? That's fair game. That will give us insight, because we can't see into somebody's mind and what they're thinking. That will give us insight on their legal analysis. And we know what she said at the hearing. There's 2 hearings, one's the 7th Circuit and one United States Supreme Court. And I will say in her confirmation hearings, Judge Barrett has said, quote, I am not hostile to the ACA at all. But this statement contradicts the things she said about the ACA before her nomination to the court. I believe now what I believed in 2017. Judge Barrett's writings show her to be clearly opposed to the ACA. And my view is that no one, not even a judge, should weaken those protections for health care in this country during a once-in-a-lifetime pandemic. The Affordable Care Act, it's a crucial part of the nation's response to coronavirus. Without it, insurance companies would be able to charge more or even deny insurance to people with pre-existing conditions. That includes the more than 95,000 Nevadans who have had COVID-19 to date, because contracting that coronavirus is a pre-existing condition. It includes another 1.2 million Nevadans with other pre-existing conditions, from asthma to cystic fibrosis to depression. Without the ACA, Insurance companies would also be able to consider pregnancy a pre-existing condition, as they used to. The 1.5 million women in Nevada could be charged more for their care than men, and lifetime and annual benefit caps could be reinstated. If the Affordable Care Act is repealed or found unconstitutional, insurance companies would be able to kick children off their parents' insurance before the age of 26. Across the country, without the ACA, more than 20 million people would lose their health coverage, and over 135 million Americans would lose protections for their pre-existing conditions. And if the Supreme Court eliminates the ACA, millions of newly uninsured people will be unable to afford coronavirus treatment. If you don't have insurance and you contract COVID-19, you are looking at tens of thousands of dollars in hospital bills. And let me tell you, this is especially alarming because COVID-19 has hit communities of color the hardest, including in my state. In Nevada, a third of our population are Latino, with another 10% of the population African American, 9% fastest growing Asian American Pacific Islander population in the country, 2% Native American. Among COVID-19 cases, however, these numbers are practically turned upside down. 45% of Nevada's COVID-19 cases are among Latinos, who make up 29% of the population. And 29% of the cases are among white Nevadans, who are 45% of the population. Nevadans of color are also overrepresented in the numbers of those who have lost their lives during this pandemic. In Nevada, 12% of those who have died of COVID-19 are African American, and another 12% are Asian American Pacific Islander. We also know from national data that COVID-19 has a particularly devastating effect on children of color. Of those under 21 who have been killed by the coronavirus, more than 75% have been Hispanic, Black, or Native American. In addition, the coronavirus pandemic has had a disproportionate effect on pregnant women of color and their babies. Nationwide, Latino mothers make up nearly half of the coronavirus cases among pregnant women, according to the CDC data through August. Young people and communities of color are also seeing the greatest economic impacts as a result of this pandemic. They're losing jobs and health care at higher rates. A recent study suggested that job losses would mean that 5 million Black, Latino, and Asian Americans would lose health care during the pandemic. People in these communities don't always have the financial reserves to keep a roof over their heads, let alone access critical physical and mental health care. Repealing the ACA would just further jeopardize these Americans, including millions in my home state and across this country. And without the ACA protections, women in Nevada would also see adverse impacts on their health. That's because the ACA requires insurance plans to offer women essential benefits like annual wellness exams, preventative mammograms and other screenings, maternity care, and access to free birth control. If the law is struck down, these benefits would go too. In fact, Judge Barrett publicly signed a statement of protest against the ACA contraceptive coverage requirements. She said that those requirements were, quote, an assault on religious liberty when applied to religious employers and institutions. But that's just the first part of the danger that Judge Barrett represents to women's health. She puts reproductive health rights at risk across the board. In 2006, Judge Barrett signed a letter that called for, quote, an end to the barbaric legacy of Roe versus Wade. As a judge, she's repeatedly voted to rehear cases that struck down unconstitutional abortion restrictions. During her confirmation hearing, she refused to describe Roe versus Wade as a super precedent that could no longer be challenged. These views suggest, and her written views and comments suggest that, as she predicted in a 2016 speech, a Trump nominee to the Supreme Court would mean that the restrictions on abortion would change and that the court would likely increase how much freedom states have in regulating abortion. And if those states have more freedom to regulate abortion, it will lead to a patchwork of different laws in different states. A recent study suggests that if Roe versus Wade were overturned, the closest abortion clinic would close for 41% of women across the country, and the distance to the nearest clinic would increase from an average of 36 miles to an average of 280 miles. In 2020, American women shouldn't have to choose what state to live in based on what kind of health care they think that they can get. These are fundamental rights that shouldn't be up for grabs. More than 80% of Nevadans believe that women should control their own reproductive choices, and I stand with them. I'm also concerned about the impact that Judge Barrett would have on LGBTQ Nevadans if she is confirmed to the court. The ACA contains specific protections against discrimination based on gender identity. The Trump administration has already weakened these protections significantly. If the ACA is struck down altogether, people who don't conform to gender stereotypes, including transgender Americans, could face increased discrimination in health care. A study of transgender patients before the ACA went into effect found that 1 in 5 had experienced discrimination from doctors, and that 28% had postponed medical care in the past in order to try to avoid that discrimination. Judge Barrett could also pose a considerable threat to the LGBTQ individuals in other ways. During her confirmation hearings, she refused to say whether she agreed with the decision in Obergefell versus Hodges, which established the right to same-sex marriage nationally. In 2015, she publicly signed a letter stating that marriage is founded on the indissoluble commitment of a man and a woman. She has also publicly argued that Title IX of the Civil Rights Act does not apply to transgender Americans, noting that it seems to strain the text of the statute to say that Title IX demands that the government guarantee transgender bathroom access. So again, I am very concerned that if she's confirmed to the court, Judge Barrett will be an additional vote to strike down things like same-sex marriage and imperil the health of LGBTQ Nevadans. The truth is that Judge Barrett's views on a whole host of issues are far from mainstream. In her short time on the Seventh Circuit Court of Appeals, Judge Barrett has sided with corporations over workers and consumers in a majority of business-related cases, resulting in the erosion of workers' rights and consumer protection rights. She has suggested that voting rights should be more easily restricted than the right to possess firearms. And she has ruled that the Age Discrimination in Employment Act does not protect job applicants from hiring practices that harm older Americans. Now, I have received over 18,000 letters from Nevadans opposing her confirmation. That is compared to 3,900 supporting it. So clearly, Nevadans are concerned that Judge Barrett doesn't share their views, and they're right to be concerned. The Supreme Court makes decisions about so many issues that affect our communities, and it will be lifelong. People in this country care deeply about issues, and in so many cases, Judge Barrett's views are out of step with what large majorities of Americans want. 77% of Americans think we should stop unlimited dark money from influencing our politics. But a 6-3 conservative court would slam the door on campaign finance reform, allowing corporations and other groups to throw their wealth behind their pet policies. Americans believe voting should be easy, safe, and secure, and that you shouldn't have to risk your health during a pandemic to cast your ballot. But again, a 6-3 conservative court with Amy Coney Barrett on the bench, would make it harder for people to vote, especially people in low-income communities and communities of color. And again, bear in mind that we're in the middle of an election. If she's confirmed tonight, Justice Barrett will also be in a position to rule on any legal disputes about that election. And that's one of many, many topics that she simply refused to answer questions about during her confirmation hearings. Now, it's understandable for a judge to avoid questions about a case that may come before her so that she doesn't prejudge the outcome. But Judge Barrett refused to answer the most basic of questions that any high school civics student knows the answer to. She wouldn't say whether the Constitution allows Congress to protect the right to vote. Answer, it does, in at least 5 separate provisions. She wouldn't say whether the President of the United States can delay the election. Answer, he can't. That's not within his authority. She wouldn't say whether the President should peacefully transfer power to the winner of a presidential election. The most important American principle is that we, the people, get to decide who governs us. But Judge Barrett refused to even affirm that. And she wouldn't say whether voter intimidation or voting twice in an election is illegal. Well, it is. Those laws are clearly on the books. It doesn't take a constitutional scholar to interpret them. People in Nevada and across the nation need to realize that many of the rights protections they enjoy are one vote away from being ended by the Supreme Court. There are at least 120 landmark Supreme Court cases from the past several decades that were 5-4 decisions, with Justice Ruth Bader Ginsburg the deciding vote in the majority, and Justice Antonin Scalia, whose judicial philosophy inspires Judge Barrett, in the minority. There's every reason to think Judge Barrett would take positions like Justice Scalia's in those areas and more. With Amy Coney Barrett on the court, American civil rights, workers' rights, reproductive rights, health care, and yes, their voting rights are at risk. For all of these reasons, Judge Barrett is not only the wrong nominee, but she comes at the wrong time. Now is not the time to rush a nominee onto the court. Now, as millions fill out their ballots, is not the time to deprive the American people of a voice in choosing the next president who will choose the Supreme Court justice. Now is not the time for us to focus on the immediate crisis at hand. We need to act to save lives and to protect families in Nevada and across the country. We need that focus now on what our families are dealing with because of this pandemic. And that's why our focus should be on passing another comprehensive COVID-19 stimulus package. We need pandemic unemployment insurance for those who have been laid off or furloughed through no fault of their own, and subsidized health coverage for those workers. We need additional funds to address the health aspects of this pandemic, everything from PPE to COVID-19 testing and tracing to funding to develop vaccines and treatment. We need rental and homeowners assistance to keep people safe in their homes as winter approaches. Our small businesses need extended PPP so they can retain staff, and many of our large industries need support as well. State, local, and tribal governments must have assistance so they can afford to fund EMTs, police, firefighters, and healthcare providers, not to mention teachers who are reinventing education on the fly. All of these essential services are keeping our community safe and functioning during this crisis. Listen, I could keep going on and on with this list, or I could just simply point my colleagues to the HEROES Act, which the House passed months ago. If Senator McConnell really wanted to get meaningful relief passed, he would do it. We know he can move quickly because we can see that with this Supreme Court nominee. If he would just come to the table with senators from both parties who are eager to find a compromise to help out their constituents, and he could make that deal happen, that's what should happen. Instead, he and a majority of this chamber have decided to fast-track this nominee. They have decided that the most important thing they can do for the nation during a once-in-a-lifetime health crisis is to confirm a justice to the United States Supreme Court. The cruelty and blindness to the real needs of Americans is astounding to me. Instead of working together for our constituents, Republican leadership is focused on a last-minute power grab that threatens Americans' health. I can't support that. There is no reason to rush this nominee. There is every reason to act on a comprehensive COVID-19 relief package. It's what we should have been doing months ago. My priority is and will continue to be getting Nevadans the comprehensive and meaningful support that they need right now. Thank you, Mr. President. I yield the floor.
Senator from Pennsylvania.
Thank you, Mr. President. Mr. President, I rise to speak about the nomination of Judge Amy Coney Barrett to be an Associate Justice on the United States Supreme Court. That has been the subject of, I know, of a number of floor remarks tonight and this morning. We know that in terms of the history of a nomination at this time before an election, no person has ever been confirmed this close, just days away from a presidential election, and no election, of course, has had so many votes cast this early. 59 million is the last number I saw a couple of hours ago. This is all happening, this rush confirmation process, while people are voting, all while Republicans here in the Senate are ramming a nomination through and not voting on a COVID-19 relief bill, which should be the subject of our work at this time, in my judgment, because of the nature of the pandemic, the threat that it still poses, and the relief that is needed all across the country. But as much as we focus in this debate, in the Supreme Court nomination debate, as much as we focus on this judge from the Seventh Circuit Court of Appeals, ultimately it's really, in the end, not about her nomination. In the end, it's about real people's lives, especially as to how the Supreme Court will impact those lives, those families, when it comes to the Patient Protection and Affordable Care Act. That will be the focus of my remarks this morning. This is a debate about people, and I'll talk about a few people from Pennsylvania in my time here on the floor. People like Aaron Gabriel, who's from Beaver County, Pennsylvania, right on the Ohio border, way out in the western part of our state. It's about Aaron and her 11-year-old daughter, Abby, as well as Shannon Striner. Shannon is from Pittsburgh, not just a little south of where Aaron is from. And I'll be talking about Shannon and her 4-year-old daughter, Sienna. But I'll start with Aaron Gabriel's daughter, Abby, and I'll use this photograph to tell everyone who Abby is. Abby's this child in the middle, and she's in this picture with her brother and sister. And here's what Aaron Gabriel said about her daughter. She said, "My youngest daughter, Abby, just celebrated her 11th birthday last Saturday." This is just in the month of October, this month. That was something that was never promised to us. Abby is growing up in her community with her family and friends. Normally, she enjoys shopping, going to the movies, Disney on Ice. She travels, she swims at a local lake, and she snuggles with her dog at home. She rides all the rides at Idlewild, which is a local amusement park. Abby is autistic, deaf-blind, nonverbal, and has a rare progressive neurological syndrome affecting multiple organ systems. with a long list of life-threatening symptoms that we're all still trying to learn more about. Medically, Abby has to go through a lot. She sees multiple specialists in Pittsburgh, Cleveland, and Boston. She has ongoing blood work to monitor her anemia and to watch for signs of leukemia. She has regular EEGs and MRIs to monitor the progress of her seizures. She uses hearing aids and glasses, a wheelchair, and a speech-generating device. She relies on protections for people with pre-existing conditions, and she relies on the ban on lifetime caps to access this care. Without the Affordable Care Act, Amy would be uninsurable, unquote. Then Aaron goes on to talk about the benefit of living in Pennsylvania because of some extra protections that Abby has. And then she continues, and I'm quoting, because she receives this care, Abby is right now healthy, happy, and thriving. As you might expect, Abby is considered very high risk should she contract COVID-19. Abby has not been inside any building that is not our home or a hospital since March 10th of this year. Summer vacations, play dates, outings, travel plans to visit grandparents, they've all been canceled. This fall, we pulled Abby out of her school, the place that had become community to her over the last 8 years, to homeschool her. She, like many children with disabilities, simply cannot access a virtual education, and it's not safe to send her back into a school building while this virus is spreading. But Abby misses her school and her friends. Normally, ongoing speech, occupational, and physical therapy help Abby to keep the progress she has made, learning to walk, to eat, swallow, and to communicate. But with COVID-19, they've all come to a halt. It's just not safe, and it's also provided us a window into what her world looks like without access to these therapies. So that's just part of Abby's story, as told to us by her mom. As I mentioned as I made reference to in the statement of her mom, Aaron wrote that Abby would be, quote, uninsurable, unquote, without the ACA. I got to ask, are we really going to say again that children like Abby are uninsurable? Are we going to allow that to happen in America? Is that the intent of this whole exercise? The exercise that is played out over years now, years of repeal efforts. All of them so far have failed. So the second strategy was to run cases up through the judicial system to get to the Supreme Court, and then ultimately to stack the court with right-wing justices who could then strike down the Affordable Care Act. That's what we're heading towards right now. Is that America? Is that the America we want? Where we advance health care to make sure that families like Aaron's and that her daughter Abby have all the protection, all the coverage that she needs? After all the progress that's been made? Instead of coming together and saying we're going to make improvements to our healthcare system, but we're going to grow the number of people that are covered, and we're going to ensure that any child like Abby has the protections that she needs, that her family should have a right to expect in the United States of America, the most powerful, the wealthiest country in the history of the world. Aaron went on to say, quote, because she receives this care, the care she's getting now, largely because of the Affordable Care Act, not to mention Medicaid, largely because she receives this care, Abby is healthy, happy, and thriving. So I got to ask, What does justice demand here? St. Augustine said hundreds of years ago, without justice, what are kingdoms but great bands of robbers? So any government, certainly our government, that makes it possible for a child to have those protections, those programs, those services, the therapies, and I could go on, and then takes an action that could result, and if this law is struck down by the Supreme Court, will result in those benefits and protections either to have been taken away or to be threatened or undermined or compromised or limited. Any government who does that is robbing that family of justice. I mentioned earlier that Shannon's daughter, Sienna, is another example of what we're talking about here. Here's what Shannon says about Sienna, her 4-year-old daughter with Down syndrome. She says, Sienna is a remarkable little girl that loves life. She is a smiley, energetic, empathetic ray of sunshine. Her favorite activity is spending time with her big sister, whom she adores. If we let her, she would watch Sesame Street all day. Elmo is a way of life in our house. She loves music, books, therapy, and playing outside. She's mischievous, funny, and beautiful. She has the ability to bring smiles to our family. On the worst of days, we wouldn't change one thing about her. Sienna happens to have an extra copy of her 21st chromosome, also known as trisomy 21 or Down syndrome. Sienna's diagnosis came as a surprise to us after enduring 4 miscarriages. She was our miracle baby. Our miracle baby surprised us on the day of her birth with her diagnosis and a heart condition. We were completely unprepared to raise a child with a disability. After I delivered her, a kind nurse explained to me how lucky we were to have Sienna here in Pennsylvania after passage of the Affordable Care Act. And then she went on to talk about how Pennsylvania had some benefits in Medicaid. And then Shannon continues, as I entered this new world of early intervention, therapies, and medical needs, I began to realize just how much of a financial toll this would take on all of us if it weren't for the protections of the ACA and Medicaid. Custom orthotics, outpatient weekly therapies, overnight hospital stays, adaptive strollers, walkers, safety sleepers, echocardiograms, communication devices, blood work, the list goes on. Sienna receives 7 weekly therapies. The cost of those alone are $3,400 per week. Without the ACA, her therapies and medical care would have quickly exceeded the lifetime cap, and Sienna would be uninsurable for the rest of her life and left without access to life-saving care. Shannon goes on, I'm proud to be Sienna's mom. The journey is full of wonder, joy, and unimaginable love. It changes life's most ordinary moments into the extraordinary. But with constant attacks on our health care, it's also agonizing work, hard decisions, and constant advocacy. It gets exhausting, fighting for your child, having to prove their value to the world. And she goes on at the very end. Once again, we as parents are forced to suit up for battle and prove that our children are worthy of health care. Her last line of this statement is, everyone loses if our children are unable to reach their fullest potential. So that's Shannon talking about Sienna, her daughter. She used that same word that Aaron used. Different stories, similar burdens, but she used that same word that Aaron used, uninsurable. Uninsurable if the Affordable Care Act is taken away. She talks about life with the Affordable Care Act and without it. And that's what a lot of parents do when they write to us. They tell us what their life was like before the Affordable Care Act and what their life is like now, and what their life would return to. Those dark days when an insurance company could make a determination about a child's insurance, their coverage, their treatment, frankly, their life. And then towards the end, she talks about what she and other parents feel under these constant attacks. Quote, having to prove their value, the value of their child. We as parents are forced to suit up for battle, and prove that our children are worthy of health care. I've asked the same question again. In America? In America, that's what we want to do? Have this constant battle? Parents have to come here to the United States Senate and to the House? The organization that this mom is a part of is called Little Lobbyists. This is a group formed because of the battles on health care. Why the hell is this going on in America? Why should we be fighting about progress that's been made? Why aren't we talking about improvements, getting the cost of health care down, getting the cost of prescription drugs down? But let's make improvements. Why do these parents have to continually battle to ensure that their children have this kind of protection? Should mothers really have to suit up for battle in the United States of America, where the powerful get their way all the time in this place? There are different kind of lobbyists that come in. They're not little lobbyists. They're not mothers and their sons and daughters. They're a different kind of lobbyists. Corporations did really well in the tax bill of 2017, a bill that was rammed through between Thanksgiving and Christmas. What did they get? Well, they got about a 14-point reduction in their corporate tax rate, permanent tax relief, jacked up the debt to do it, because they had power. I thought that was, when you compare that action that the Senate took at the time to what some in the Senate want to do on health care, to roll back the protections, to rip away protections for these children, and not even talking tonight about the adults that are impacted. But when you compare those two actions, it's really perverse and disgusting. That the powerful get to come in here and get permanent tax relief and get a bonanza, the likes of which we haven't seen in modern American history. And all these parents are asking us to do is preserve what we have. They're not asking for anything more. They're just saying, please make sure my child doesn't lose their coverage. Please make sure that they have the therapies they need when they have these complex medical needs, multiple disabilities, not one in many cases, but multiple. That's all they're asking us to do. And that's why it's such an important matter in the Supreme Court fight. Because you got to ask, why the rush to get this nominee through by Election Day? It's never happened before this close to an election. Well, I'll tell you why. This nominee is being fast-tracked, first of all, because this nominee has been vetted by the two groups that matter, the Federalist Society and the Heritage Foundation. Both groups totally committed to striking down the Affordable Care Act. So she's already passed that test, and she apparently passed with flying colors as she moves very quickly to a likely confirmation. But why the fast track to get there in a matter of days? What's coming up? Is it Election Day? No. There's a date after the election. It's November the 10th. That's the argument date. They know that if she is not on the Supreme Court, is she not confirmed as a member of the court by the argument, November the 10th, she can't participate in the decision. What's the decision? The decision to strike down the Affordable Care Act. That's what it is. The decision that really is the proxy for what did not happen on the floor of the United States Senate in July of 2017, when the repeal effort failed, and when it failed multiple times in the House over many years. This is the proxy for it. Litigate it, fund it, and run that case right up the chain to the Supreme Court. So that's what this is about. They want to make sure that she is on the court and at the argument so she can be the deciding vote on the Affordable Care Act. That's why we're rushing. How about another health care issue? How about Medicare? I mentioned Medicaid. How about Medicare? The program that used to have bipartisan support all across the board. Now, Judge Barrett was asked a direct question about Medicare, and she didn't want to give an opinion on Medicare. She was asked it in the context of the constitutionality of Medicare. And the member of the Judiciary Committee, Senator Feinstein, asked it because she referenced a law review article about questioning the constitutionality of Medicare. I think that's a loopy theory. I think that's a theory that most Americans, probably 90% of Americans, don't agree with. Questioning the constitutionality of Medicare, passed more than 50 years ago, and has benefited tens and tens and tens of millions of Americans, still today benefits numbers like that. 45 million, roughly, I think it is. I don't know why. I understand why the judge doesn't want to say, well, in this case, it's before the court, or this case that is unsettled, I can't give you a determination. But on Medicare, couldn't she have at least said, instead of mentioning, as she did in her answer, the law professor's name twice, who has this loopy theory on Medicare constitutionality, couldn't she have said simply, well, I can't tell you how I'm going to rule on a Medicare case, but I can tell you that just like Brown v. Board of Education is a super precedent in a judicial sense, I think most people would agree that Medicare is a super precedent in a legislative sense. She wouldn't have violated any principle of not telling how you're going to come down on a case. She could just tell us or relate to us the reality that most Americans believe about Medicare. Now, I know there's been some commentary about her law review article her writings about the 2012 Supreme Court case. Now, we know that the case she was referring to was a 2012 case. So in 2017, Judge Barrett wrote an article about what Chief Justice Roberts ruled in the case. She wrote, quote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute, unquote. In light of her frequent criticism of the act, the Affordable Care Act, Senator Leahy of Vermont asked her during her confirmation hearing whether she had ever written or spoken in favor of the law. She has not. So that's what she was writing in 2017. I have to ask, if she felt so strongly about the 2012 decision by the court and and the position of Justice Roberts, she didn't seem to write much about it for a couple years till 2017 when you had a new president. And what followed a few months later was she was nominated to the Circuit Court of Appeals. So that's curious. But what we know is that the president that nominated her, President Trump, certainly wants to strike down the Affordable Care Act. And in fact, in May, he said he wanted to, quote, terminate health care, unquote, under the Affordable Care Act. And we know the impact of that, the destruction, the act of striking down the Affordable Care Act would harm tens of millions of Americans. In Pennsylvania, 5.5 million people with a pre-existing condition would be affected. Over 840,000 Pennsylvanians who were enrolled in Medicaid expansion would be, of course, adversely impacted. So that's the reality of what we're talking about with regard to this nomination. I'll mention make reference to one more family before I conclude my remarks, Mr. President. It's the Kovacs family also from western Pennsylvania, Plum Borough, Pennsylvania, in Allegheny County, not too far from Pittsburgh. The Kovacs' 11-year-old son, Thomas, is blind and has multiple disabilities. He has epilepsy, microencephaly, and intellectual disabilities. His mom, Jessica, says the Affordable Care Act has made all of their lives better. The ACA has made it possible for Thomas to receive therapy services at his school, Center Elementary School in Plum Borough. The ACA has given his parents the option to change jobs and advance in their careers without fear of not being able to obtain health coverage for him because of his pre-existing conditions. And they don't need to worry about busting through lifetime expense caps and losing coverage for Thomas. The ACA has brought peace of mind and comfort to their family because they know that he is protected by the essential health care benefits the law provides. Striking down the ACA isn't only about the essential health benefits, it's about a lot more than that. There's so much more that I could talk about tonight, so many more examples, but I'll conclude with that, Mr. President, and just make one final comment. When I think about what could happen and what is likely to happen if Judge Barrett is confirmed, becomes a member of the court, participates in the argument on November the 10th, and then because of that participation is allowed to, and as a member of the court is allowed to rule on this ACA case, it's highly likely that the Affordable Care Act will be wiped out. And I have to ask about the fate of Abby and Sienna and so many other children like them all across our Commonwealth and all across the country. I think often in government, we must ask, here in the United States Senate or in the House or in the other branch of government, the judicial branch, or in any branch of government, the executive, legislative, or judicial branches, we should all ask ourselves, is this action I am taking, or is this policy or program advancing the cause of justice or not? Mr. President, I would submit that striking down the Patient Protection and Affordable Care Act by virtue of a Supreme Court decision is not only the wrong policy, it is a giant step backwards in the interests of justice. Justice demands that these children have these protections, that these protections are not undermined, they're not compromised, and they're not taken away by judicial fiat. And this nomination threatens the health care that children like Abby and Sienna have right now in the United States of America, where we advanced into the light of protection for those children. And when you consider what is at stake right now, it's that case. I think it's potentially the most important case the court will decide in the next quarter century. That's the impact of it. Very few Americans are not directly affected by this case, either because they're affected by way of loss of coverage or they're affected because of the scope of the protections that were brought about by the passage of the Affordable Care Act, the enactment of it. So a lot is at stake, not to mention so many other issues and so many other matters that will come before the court. So for that reason and several others, I'll be voting against the nomination of Judge Barrett to be on the Supreme Court. And if I have an opportunity between now and the vote, I'll outline some other reasons why. But for purposes of tonight, this morning, I wanted to talk about children like Abby and Sienna and their moms. The moms, Erin and Shannon, should have the peace of mind that has come with the protections of the Affordable Care Act. And with that, Mr. President, I will yield the floor.
Mr. President.
The Senator from Maryland.
Thank you, Mr. President. I want to start by thanking my friend and colleague, the Senator from Pennsylvania, for talking this evening about what's at stake for so many of his constituents with this Supreme Court nomination and the very real possibility that the Affordable Care Act will be struck down and what that means to so many of his constituents. And I do think this is a moment where we need to reflect and take stock of where we are as a country on many fronts. We are in the middle of a global pandemic. We just saw the highest single day of new reported cases on Friday. Millions of Americans are unemployed and worried about how they're going to pay their rent and how they're going to pay for their medications. We're here at a time when a Republican-led lawsuit to strike down the Affordable Care Act, supported by President Trump and his Department of Justice, is scheduled for a fateful hearing in the Supreme Court on November 10th, 1 week after the upcoming election. We're here in the wake of the killings of black men like George Floyd and black women like Breonna Taylor, which sent throngs of protesters into the streets across the country to rightly demand greater police accountability and racial justice. We gather here as wildfires in the West and hurricanes in the South demonstrate with deadly and destructive ferocity the accelerating and dangerous consequences of climate change. And we meet, Mr. President, as voters are filling out mail-in ballots as early as they can to make sure that the Postal Service, which this administration has deliberately slowed down, can get their ballots delivered on time so that they can be counted. And as voters stand in long lines with their masks 6 feet apart to cast their ballots in the early vote. Mr. President, at this moment, this country is facing all these pressing issues, but as I come here this evening or early this morning, we're not considering solutions to any of those critical and urgent issues. Not a single one. Instead, we are blowing up the precedent that the Senate Republican leader and other Republican senators themselves established 4 years ago, and considering a Supreme Court nominee closer in time to the presidential election than ever before in American history. Than ever before in American history, as millions of Americans have already cast their ballots. We are blowing up this Republican Senate established precedent and racing toward a nomination that will turn the clock back, take us backwards on all of those pressing issues that I just outlined. But sadly, I suppose none of us should be surprised that we are focused here on another judicial nomination at the expense of focusing on legislation to advance and address the interests of the American people on so many front burner pressing issues. Indeed, as I reflect on the last months and years, just about the only thing this Republican Senate has done is pass nominations. Week after week, we ignore our job as legislators in favor of an agenda of rubber stamping, blindly supporting whatever nominee this president puts forward. In many cases, it hasn't even mattered if a judicial nomination is qualified, if they've even tried a case. Our Republican Senate colleagues have abandoned any principles they claim to hold with respect to our judiciary. When President Obama was in office, those Republican senators who were here in this chamber erected a wall of opposition to scores of his nominees, refused to even consider many of them. They outright rejected President Obama's efforts to fill seats on the D.C. Circuit, the court just below the Supreme Court. Republican senators at the time claimed that it wasn't necessary to fill those vacancies. They rejected qualified nominees up and down the bench, denying simple consideration and withholding blue slips. It was a deliberate effort to stonewall President Obama's judicial nominees. In fact, they rejected a highly qualified nominee for the very seat Judge Amy Coney Barrett currently holds. President Obama nominated Myra Selby for the Seventh Circuit in January of 2016. She had served on the Indiana Supreme Court and would have been the first African American and first woman from Indiana on that circuit. Senate Republicans, what did they do? Didn't even give her a hearing. Then, 1 month later, February 2016, Justice Scalia passes away. President Obama nominates Merrick Garland to the Supreme Court, a good and very fair judge who had been confirmed to the D.C. Circuit by a Republican-controlled Senate by a vote of 76 to 23. What did Senate Republicans do? They refused to consider the nomination. They said February of 2016, February of that election year, was simply too close to a presidential election to fill the slot. The American people should have a voice, they said. Let the people choose a president this year, and then let that president, whoever it may be, make the nomination to the Supreme Court. And not only did Senate Republicans oppose Merrick Garland, they refused to meet with him. They refused to hold a hearing. This is February 2016. The American people should have a voice. It's a presidential election year, they said. 8 months before that November 2016 election was just too close. And yet here we are today, 4 years later, 8 days, not 8 months, 8 days from the beginning of the last day of this presidential election, November 3rd. Over 50 million ballots already cast. And suddenly, There's nothing more important than rushing to fill a Supreme Court vacancy. Not responding to a global pandemic, and we just learned from a very reputable Columbia University study that had this administration acted and followed the advice of healthcare experts, we could have saved at least 130,000 American lives, up to 220,000 American lives. But here, we're taking no more meaningful action, not giving a lifeline to people who are out of work through no fault of their own, not closing the digital divide so children who can't go to school because of COVID can access their classes, not reforming our justice and policing system to make sure that everyone, no matter the color of their skin, is protected and treated equally. Not securing our elections against foreign attacks and interference. Just a few days ago, I was right here on the Senate floor asking this Senate to take up what had been a bipartisan piece of legislation called the Deter Act. I introduced it years ago with Senator Rubio after we learned of the Russian interference in 2016. We wanted to make sure that we sent a clear message in advance of the 2020 election that if we catch the Russians or any other adversaries interfering in our election, this time there'll be a swift and certain price to pay. And just earlier this past week, we got not surprising news from the DNI that, yes, what we've known all along, the Russians are interfering, other adversaries are interfering, and yet we couldn't even take up the bill, a bipartisan bill, to send a clear message to Putin and others, because the Trump administration continues to oppose it, and the Senate Republican leader continues to bury it here in the United States Senate. So no response to global pandemic of meaningful note at this point, nothing to do on justice and policing, nothing to secure our elections. No, the top priority has been to jettison the precedent that our Republican colleagues themselves established under President Obama 4 years ago and rush to confirm a Supreme Court justice. Why? Why this 180-degree turnaround? After all, it's not as if our Senate Republican colleagues have always been so worried about an 8-person Supreme Court. They kept the Supreme Court to 8 justices for a year, for a full year, when they refused to consider Merrick Garland's nomination. Some of our Senate Republican colleagues raised the idea of only having 8 justices on the Supreme Court forever if Hillary Clinton had won the presidency in 2016. So what's different this time around? Well, as we've been hearing on the floor of the Senate and from the President himself, there are a number of irresistible opportunities, at least irresistible for the President and our Republican colleagues, things they've been trying to do for years and have not succeeded yet in doing. First, they can pack the court with increasingly ideological and right-wing justices to align the very top court, the Supreme Court, with the increasingly ideological right-wing judiciary they've been creating over years, first by stonewalling and blocking President Obama's nominees, and then fast-tracking them for President Trump's nominees. Second, they can achieve another goal that they've been striving for a decade: overturning the Affordable Care Act. 10 years ago, I was a member of the House of Representatives at the time. Republicans did everything, and I mean everything they could, to block passage of the Affordable Care Act, to stop Obamacare. We heard outright lies about it. They said it was going to cause massive job loss. They said that the government would be picking your doctor. They said a government panel would decide whether your grandparents lived or died. They called them death panels. None of it was true. None of it has come true. The first part of the Affordable Care Act was signed into law on March 23rd, 2010. On that very day, House Republicans filed a bill to repeal it outright. Also on that same day, the first Republican lawsuits were filed against it. That two-pronged approach, trying to undo it legislatively and trying to undo it through the courts, continued for the next decade. Dozens of votes in the House of Representatives and the Senate to attempt to repeal the law, and dozens of Republican attorney generals and special interests filing lawsuits to challenge it in the courts. They failed. They failed in the Congress, and so far have failed in the courts. In the courts, in 2012, the Roberts Court upheld the constitutionality of the Affordable Care Act in a 5-4 decision in one of the very first cases that had been filed against the law. It wasn't a complete victory for the Affordable Care Act. It did make Medicaid expansion optional, and a number of Republican-held states have refused to implement that unless and until voters have demanded it at the ballot box. But that Supreme Court decision did uphold the central tenets of the Affordable Care Act. The Supreme Court upheld the ACA again in a 6-3 decision in 2015. But that hasn't stopped the Republican Party's quest to eliminate it entirely. Just look at the 2016 Republican Party platform, where they continued the attack with 3 strategies. First, President Trump, and I quote, "with the unanimous support of congressional Republicans, will sign its repeal," unquote. Second, while working to legislatively repeal it, the president would use his administrative authorities to undermine, weaken, and sabotage it. Third, the president would appoint justices to reverse past decisions, including the Affordable Care Act decisions made by the Supreme Court. That was the 3-pronged plan. Well, they ran into problems with the first part of the plan, because despite President Trump's campaign promise to convene a special session of Congress to, quote, "immediately repeal and replace Obamacare," quote, "very, very quickly," unquote. Despite that pledge, our Republican colleagues soon realized they had no replacement plan. They promised that they could repeal the Affordable Care Act and replace it with something much, much better and less expensive. But there was no real plan. There was no there. And the idea they offered to the American people was to trade health care for millions of Americans for tax breaks for the very rich. Tens of millions of Americans would have lost access to affordable health care. People with pre-existing conditions would have lost protections. Deductibles and copays would have gotten more expensive, and insurance companies would have been able to get tax breaks on the bonuses they gave to their CEOs. That's what was in the Republican replacement plan. Giving tax breaks to companies for the bonuses they paid to their CEOs. Not surprisingly, they couldn't sell it to the American people. And I think we all recall here in 2017, it dramatically failed by 1 vote in the United States Senate. Every Democratic senator voting against destroying the Affordable Care Act, 3 Republicans joining us, including, of course, Senator McCain, giving it a big thumbs down. Republicans have been a little more successful trying to sabotage the law through the Trump administration's executive authorities by scaling back outreach for enrollment plans. What does that mean? That means don't tell the public about what opportunities they have to get health care coverage in the Affordable Care Act. We just won't provide as much public information, so people won't know about it, then they won't be able to sign up for it. Also, by ending cost sharing in an attempt to destabilize the health care exchanges and allowing more junk health plans that don't offer critical benefits or protections. The kind of plans we used to see when people thought that they had coverage, and then when they really needed it, they suddenly discovered, nope, in the fine print, it just wasn't there. But despite these efforts by the administration, the law has survived. All their efforts to slash it with 100 cuts, it continues to provide affordable coverage to millions of Americans, and in many states, including mine in Maryland, they've taken efforts to try to protect the Affordable Care Act from the Trump administration's attacks. But on November 10th, when the Supreme Court hears that Affordable Care Act case, all of that could change. They could decide, after upholding it on two separate occasions, that now they've got another Supreme Court justice, we're going to strike it down. And make no mistake, Donald Trump wants this law overturned. I mean, no one should be under any illusions about that. You can take it from the word of the brief, the legal brief filed by the Solicitor General of the United States on behalf of the Trump administration. He's the country's lawyer before the Supreme Court. He filed the case and said that the entire law, quote, must fall. The entire law must fall. Not one piece of it or another piece, the entire law must fall. That is the position of the Trump administration. You can listen to President Trump back in May of this year. We're in the middle of a pandemic when he said, and I quote, "We want to terminate health care under Obamacare," end quote. You can listen to him just this week in 60 Minutes. It aired tonight. And he tweeted out to make sure everyone could see it, just in case they missed the show. President Trump said of the Supreme Court's ACA case, and I quote, "I hope that they end it. It'll be so good if they end it," unquote. That's President Trump. It'll be so good if they, the Supreme Court, end the Affordable Care Act. That's been his plan from the Supreme Court from the start. In 2015, when he was running, he said, and I quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee John Roberts on Obamacare," end quote. Candidate Trump hasn't changed his tune. And he has found his nominee in Amy Coney Barrett, who has publicly criticized past Supreme Court decisions on the Affordable Care Act. She is President Trump's torpedo aimed at fulfilling his pledge to destroy the Affordable Care Act. She criticized the decision in NFIB versus Sebelius, saying that Chief Justice Roberts' argument pushed the Affordable Care Act beyond its plausible meaning to save the statute. She applauded the dissent in King v. Burwell, saying that they had, quote, the better of the legal argument, end quote. So it's no wonder that Republican senators who tried unsuccessfully to defeat the Affordable Care Act legislatively in 2017 are now rushing to appoint her before that case is heard 1 week after the election. The stakes could not be higher for the American people. I want everybody to think back to the days before we had the Affordable Care Act. Back then, if you had a pre-existing health condition, companies could deny you coverage outright. If you didn't have the coverage, you might otherwise be offered it at a price that you couldn't possibly afford, outrageously expensive. Instead of denying it outright, we'll offer you that coverage, but you've got a pre-existing health condition. So we're going to charge you something that you can't possibly afford. And so you can't buy it. If you did have coverage and then developed a health issue, you'd be locked into your current plan no matter how high the costs arose, unable to shop around because of what had become a pre-existing condition. It's called job lock. You have to stay in a job even if you have a better opportunity or you want to pursue your dreams because you now have a pre-existing health condition and you can't get coverage elsewhere. One Marylander, Angela, wrote to me about her daughter, Rachel, who was diagnosed with epilepsy when she was in 8th grade. She had to take expensive medications, which she can afford thanks to the Affordable Care Act. Here's what Rachel's mother wrote, quote, "She now has a lifetime pre-existing condition. If she were to be kicked off her health care, I imagine she would be bankrupted, having to pay full costs of the medications that help her be a productive member of society." Rachel's a teacher, and her mother, Angela, says, quote, "It is because of Obamacare that she is able to be where she is today." Another constituent, Megan, wrote to me that she turned 26 on the Thursday that the Senate Republicans on the Judiciary Committee reported out the Barrett nomination. She turned 26 just last Thursday. She has asthma. She pays $60 a month for her medications. And here's what she wrote to me, quote, "If I lost my job or my insurance, I would have to make a choice between my medicine or paying the electric bill on time," unquote. And she ended her note to me with the following, quote, "For my 26th birthday, my only wish is that the Affordable Care Act not be overturned. There are so many people like me, Americans with pre-existing conditions, that depend on this crucial legislation that provides necessary protection and guarantees that they will stay covered no matter what." That's what Megan wrote. And before the Affordable Care Act, women could be charged more just because they were women. Being a woman was a pre-existing condition that allowed insurance companies to charge more. It's also true that before the Affordable Care Act, if you had a catastrophic accident or a long-term health issue, you would hit a coverage gap and be bankrupted by millions of dollars in hospital bills. There were no annual caps and no lifetime caps. Sometimes that meant that people wouldn't go to the hospital or see a doctor because they didn't want to face unending, uncapped bills. That's what would have happened to another constituent of mine, Robin, if she did not have the Affordable Care Act. She wrote, quote, "I'm 64, so she's not yet 65, so she's not covered by Medicare. I'm 64, took a tumble at home. My older son urged me to go to the emergency room due to my family health history. I was kept in the hospital due to a low thyroid level and almost non-existent potassium level, among other problems. I would not have recovered if I did not have the ACA. I would not have health insurance, and I know I could not pay a hospital bill, so I would not go to the emergency room. I would have died. The Affordable Care Act saved my life," unquote. Before the Affordable Care Act, if you were a recent college graduate but you hadn't found a job with health insurance yet, you couldn't stay automatically on your parents' health insurance policy. You were on your own, out of luck, young people thinking they're invincible. until they're not. Insurance companies could deny coverage to them. Now they can't. I heard from one Marylander who worries about his son's future if this particular provision is taken away. He wrote to me, quote, "If the ACA is overturned and we lose the coverage for my son on my policy, this would be a disaster for my son and for my family. I would hate to see him have to drop out of school just to find a job to cover health insurance. It would destroy his future. And we don't have," he continued to write, "the extra $5,000 or so a year lying around that would be required for him to have a policy under our current provider that would cover his pre-existing conditions. My son could be one of the millions to lose health insurance if the Republicans have their way," unquote. This provision of the Affordable Care Act has been life-saving for Pamela's family. She wrote, "This year, my 23-year-old daughter was diagnosed with stage 3 breast cancer. Stage 3 breast cancer. Thanks to the Affordable Care Act, she's still on our insurance. Even with our insurance, she will be in debt for a very long time. Without it, she would be dead. I have not heard a single Republican guarantee this will be in any bill they propose," unquote. It's also a fact that before the Affordable Care Act, you had to pay for annual checkups and preventive coverage like breast cancer screenings. It's also a fact that if you wanted to quit your job to start a small business, you had to figure out how you would pay for an expensive health plan, which might not provide very good coverage on the individual market. Another Marylander who had a lump in her breast that was treated as a pre-existing condition even after it disappeared, decided she had to limit her employment options to those with decent health insurance before the ACA was enacted. She wrote, quote, "This experience steered me to work only for employers large enough to offer stable, subsidized health care insurance. The downside has been the golden handcuffs. It is important to have universal, decent health care coverage to encourage small businesses, nonprofits, and entrepreneurs," end quote. Kathleen from Maryland decided to leave an office job to find something that suited her better. But the job she took in the restaurant industry didn't offer any medical coverage. She wrote, quote, "I developed adult onset asthma, more than once resorting to the ERs or urgent care. I searched everywhere I knew for medical insurance, but was refused, either because I was just an individual and or because I now had a pre-existing condition. Knowing nothing about asthma treatment and unable to cover medical bills entirely on my own, I was chronically ill and more than once almost died," unquote. She had to rely on friends and family for help, and after 10 years without insurance, she finally found a job with coverage. Kathleen wrote, quote, "We all need medical coverage all the time, no matter your employment status." The Affordable Care Act dramatically expanded Medicaid in many states, those that opted to participate, providing subsidies for low-income Americans to find affordable plans, and gave small business tax credits for providing health insurance for their employees. It also closed the prescription drug donut hole for seniors on Medicare. A lot of people forget seniors on Medicare benefited from the Affordable Care Act and continue to benefit. That's part of the law that the Trump administration is trying to overturn in its entirety. These are seniors who faced a big coverage gap from an initial spending threshold and on the other side of the donut hole, catastrophic spending, a big donut hole. In 2016, in the most recent years where we have complete data, close to 5 million seniors on Medicare received an average of over $1,000 in Part D prescription discounts because the donut hole was closed. And of the 46 million seniors on Part D Medicare today, if any of them all of a sudden develops a condition that requires high drug costs, any of those 46 million Americans could fall into that donut hole, costing them as much as $3,000 more per year. Now, Mr. President, the Affordable Care Act isn't a perfect law, but it did set a key standard for essential health benefits, cut the rate of uninsured Americans, and started improving health care outcomes for Americans. And right now, while we're in the middle of the COVID-19 pandemic, it's more important than ever. The United States has had over 8.6 million COVID cases, a number that we see grow by the day. For patients who require hospitalization, the Kaiser Family Foundation reports that the average stay can cost more than $20,000 a person and rise to closer to $90,000 if the patient requires a ventilator. So, what would happen to those Americans if they're once again subjected to a lifetime out-of-pocket limit on their insurance coverage, where they are not protected against huge expenditures? Mr. President, we're all glad that when President Trump got COVID, he got world-class care. It's a good thing. We're glad he got airlifted to Walter Reed in Maryland. It's a great national military medical facility. We're glad he had a team of doctors devoted to his case. We're glad he got access to cutting-edge drugs. He won't have to pay for that coverage. But, Mr. President, that's not the kind of treatment every other American gets. And it's offensive for the president to relish his first-class treatment while denying his fellow Americans simple protections, as he would by calling for the destruction of the Affordable Care Act. Speaking of COVID-19 and the impact of pre-existing conditions, we're seeing many COVID-19 patients who have long-term health effects. They call them the, quote, long haulers, unquote. The CDC noted last month that COVID-19 can have an impact on the heart, including heart damage that can lead to long-term symptoms like shortness of breath, chest pain, and heart palpitations. An article this month in the Harvard Medical School Health Blog notes that COVID can damage the brain, causing cognitive effects comparable to those who have suffered traumatic brain injury. So, Mr. President, while Senate Republicans have refused to take meaningful action to confront the next step of COVID-19 relief, including refusing to pass a strong testing and tracing plan to halt the spread of the virus as proposed in the HEROES Act, both 1 and 2, from the House of Representatives, they're pushing for a nominee to take the Affordable Care Act away from American people who have gotten sick, and now up to 8.6 million of them have a pre-existing condition due to COVID-19, but they'll no longer be protected from that pre-existing condition if the Affordable Care Act goes away. Mr. President, this isn't crying wolf. I want to remind everybody again, the Solicitor General of the United States, acting on behalf of the President of the United States, wrote in his brief in support of the case to overturn the Affordable Care Act that the entire law, coverage for pre-existing conditions, closing the Medicare hole, ending lifeline limits for care, must fall. All of it must fall. And we know President Trump has no plan to replace it. He's had plenty of time to present one. 4 years. He keeps telling us it's going to be a matter of weeks. 4 years ago, after his inauguration, it's going to be a matter of weeks. 2 years ago, it's a matter of weeks. 3 years ago. It's a matter of weeks. He was asked about it in the last debate. He said, don't worry, he's going to come up with, quote, a brand new, beautiful health plan, unquote. Mr. President, women's health in particular is in jeopardy with this nomination. Not only do women stand to lose the Affordable Care Act protections against discrimination, because before that, as I said, just being a woman was a pre-existing condition that would and could cost you more. They will no longer have access to the guarantee of free cancer screenings for breast cancer or other screenings. But it's also a fact that President Trump and Republicans have long sought to deny them reproductive health freedom. And that brings us to another long-time priority of President Trump and Senate Republicans: putting a justice on the Supreme Court who will provide a majority to strike down a woman's right to reproductive choice in accordance with the Roe v. Wade decision. Mr. President, the Roe v. Wade decision was 7-2 in the Supreme Court. It was founded on the right to privacy, that a woman's health care choice was her own without interference from the state, in accordance with the Roe v. Wade framework. Before Roe v. Wade, when abortion was illegal in most states, unsafe abortions caused 1/6 of all pregnancy-related deaths. Many low-income women jeopardized their lives with self-induced procedures. Now, women have safe options, both to obtain abortions and also, thanks to the Affordable Care Act, no-cost contraception that is used to both plan families and manage a variety of health conditions. Women can make decisions about their own bodies in consultation with their doctors that are best for their health and the well-being of their families. And the vast majority of Americans support comprehensive health care, including a woman's right to reproductive choice under Roe v. Wade. But there's been a long fight chipping away at this protection, this care, with the ultimate goal of overturning Roe v. Wade altogether. And overturning that case has been one of President Trump's litmus tests for this Supreme Court nominee and his other picks. And like the Affordable Care Act, it's not like he's been subtle about this. In a presidential debate in 2016, he was asked if he wanted the Supreme Court to overturn Roe v. Wade. He said, and I quote, "Well, if we put another 2 or perhaps 3 justices on, that's really what's going to be. That will happen. And that'll happen automatically, in my opinion, because I'm putting pro-life judges on the court," end quote. There it is. This would be President Trump's 3rd Supreme Court nominee, the magic number he talked about for overturning Roe v. Wade and a woman's protected right to choose under the Constitution of the United States. This comes on top of more than 60 judges with anti-choice records that he has already nominated and that this Senate has confirmed to the lower courts. More states are passing laws to drastically limit or effectively ban abortion in order to set up cases to challenge Roe v. Wade in the courts, to set up those cases to take to the Supreme Court. And again, as with his intention to overturn the Affordable Care Act, President Trump has found the perfect nominee to overturn Roe v. Wade in Judge Barrett. We don't have to rely on the president's words alone or on all the anti-choice groups who have vigorously lobbied for her appointment and who have said that she believes that Roe v. Wade is something that can be reversed. That's what all the advocacy groups supporting her nomination are saying. And one of our Republican Senate colleagues said he absolutely would never vote for a justice who's not shown that they believe that Roe v. Wade was wrongly decided, and has told us that Judge Barrett, quote, certainly would meet that standard, unquote. And just as we can see Judge Barrett's opposition to the Affordable Care Act in her own record, we can see her opposition to Roe v. Wade in her own record. She signed on to an advertisement calling Roe v. Wade, quote, an exercise of raw judicial power, unquote, that advocated for ending, and again I quote, the barbaric legacy of Roe v. Wade. That's what she said. She signed another advertisement criticizing Roe v. Wade when she was a member of Notre Dame's University Faculty for Life, an anti-choice group. She has said that Roe v. Wade is not settled precedent. Indeed, at her hearing in the Senate, she questioned the principle that the Constitution protects certain fundamental rights from government interference on privacy grounds, saying that there's a debate about how far that can go, a debate that is generally waged by those looking to overturn Roe v. Wade and Obergefell, the case that allows for gay marriage. She would not even concede, and this is very telling, she would not even concede in her hearing that the decision in Griswold versus Connecticut was settled law. Griswold v. Connecticut is the case that protects access to contraceptive. It was a Connecticut law on the books that prohibited any person from using contraception, and the court invalidated that law in a 7-2 decision on the grounds that it violated marital privacy. I want our colleagues to think about this. This is a state law that said that adults could not use contraception. And she would not say that that is settled law under the Constitution of the United States. She would not even concede that in vitro fertilization, which has helped many women start their families, was constitutional and cannot be made illegal. Mr. President, it's clear from President Trump's stated intentions, from the words of anti-choice groups, the promise of our own colleagues, and from Judge Barrett's own words, that her nomination is the culmination of decade-long effort to overturn a woman's right to choose. We also see that with respect to the decision in Obergefell v. Hodges. On the day in 2015, the Supreme Court showed us what it could be, a body that would ensure rather than restrict the rights of Americans, and in a 5-4 decision, it told LGBTQ Americans that the love they had for each other and their wish to declare that love in marriage was their right, as it has been for straight couples for the whole history of our nation. 5 years later, the American people support this decision at record high levels. But that was a 5-4 decision, and we're now facing a fundamental shift in the balance of the court. And we have seen time and again this president attack laws designed to protect people against discrimination based on sexual orientation. We also see this not just from the administration, but again through Judge Barrett's own words and actions. She received an honorarium to teach a program run by the Alliance Defending Freedom, which the Southern Poverty Law Center has characterized as a hate group for its efforts to prohibit same-sex marriage and recriminalize homosexuality, and she called the experience, quote, a wonderful one. She has referred to sexual orientation as a sexual preference, which is the buzzwords used by those who want to overturn LGBTQ rights on the grounds that this is not a question of immutable characteristic, but simply someone's chosen preference. There are a number of cases coming to the Supreme Court that deal with the issue of discrimination against foster families headed by same-sex couples. One will arrive at the court on November 4th, the day after the election. Another reason you see this nomination being rushed. If you look through the issues I outlined at the start, from racial justice and police accountability to other questions of the ability to access health care, you will find time and again in Judge Barrett's record telltale signs and clear signs, flashing warning signs, that she wants to turn back the clock. We see that with respect to criminal justice reform, where she dissented in a case on whether a defendant who had been convicted but not yet sentenced when the First Step Act was enacted by this Congress and signed by the President, as to whether the new sentencing requirements of that law would apply. And fortunately, the Seventh Circuit ruled 9-3 that the First Step Act applied to the defendant. Judge Barrett was one of the 3 dissenting votes who adopted a cramped interpretation of the law, devoid of any mercy. And there are other cases relating to the rights of those who have been injured, including a pregnant teenager who was repeatedly sexually assaulted by a prison guard, where Judge Barrett found that the prison guard could not be held liable under his employment with the prison system. And if you read through that case and the horrifying facts, I think you come away very troubled with the fact that she had such a cramped reading of the law. Mr. President, on a question that's not a legal matter, but a matter of fact, climate change, we would have thought that the question that was put to her was quite easy. Judge Barrett admitted that the coronavirus was infectious. Why? Because that's what the medical experts say. But when she was asked about climate change, again, not a tricky legal question, she refused to say what the overwhelming scientific consensus is, that climate change is real. We see it, as I said, with the forest fires. We see it with the hurricanes. We see it in my state of Maryland. Just in the city of Annapolis, the home of the Naval Academy, we see flooding at our docks that is wreaking havoc on local businesses. So time and again, when Judge Barrett was given an opportunity to answer basic fact questions or pretty straightforward legal questions in the Judiciary Committee, she ducked them entirely, but we have her record to indicate where she stands. On the issue of voter protection and voting rights, we also find another troubling pattern in Judge Barrett's record. And this is especially important when you think about the fact that she's filling the seat of Justice Ruth Bader Ginsburg, who wrote that very powerful dissent in the 5-4 decision in Shelby versus Eric Holder that took a big bite out of the Voting Rights Act. And if you look at the statements by Judge Barrett, she distinguishes between what she calls individual rights, like the Second Amendment rights, versus what she calls a civic right, the right to vote, putting the right to vote in a lesser protected category than what she defines as individual rights. In fact, Judge Barrett wrote, as a right that was exercised for the benefit of the community, like voting and jury service, rather than for the benefit of the individual, it belongs only to virtuous citizens. Only to virtuous citizens. That's what Judge Barrett wrote about the right to vote. Mr. President, the right to vote, as we all know, is fundamental to our democracy. Our dear colleague, John Lewis, recently passed away and was nearly beaten to death for fighting for that right to vote, said many times, "The vote is precious, it's almost sacred. It is the most powerful nonviolent tool we have in a democracy," unquote. And Mr. President, he should not be relegated, that right to vote should not be relegated to some kind of secondary status, as Judge Barrett's writings indicate she would do. So if you look at all the challenges that we face as a country, dealing with the pandemic, dealing with issues of police accountability and racial justice, dealing with climate change, dealing with protecting voting rights, all these pressing issues that we should be focused on here in the United States Senate. We're not. And instead, we're rushing through this illegitimate process to put a justice on the Supreme Court that in each of these areas where we should be focusing our attention is actually going to take us backwards. And so, Mr. President, I urge this Senate, I can see the march that's going day after day toward the vote tomorrow, but I urge this Senate to reconsider the path that it's in. This has been a very shameful episode, watching the complete flip-flop from 2016, rushing to put on a justice who the president wants and who Senate Republicans, I think, believe will act to overturn the Affordable Care Act, take away a woman's right to choose, and be part of an ideological majority that will strip away important rights from the American people. I will end by just pointing out, Mr. President, that public surveys right now show the American people are not fooled by this process. They don't like what they see. They want us to be focused on dealing with COVID-19. They want us to pass a robust, comprehensive emergency response package. That's what the American people are calling for. Instead, this Senate is embarked on this charade of a process. There will be a verdict on all of this by the American people in a matter of 8 days. Mr. President, I believe there will be a reckoning on the actions the Senate is taking and the actions the Senate has refused to take in addressing the urgent issues that are really facing the country. And I yield the floor.
Senator from Hawaii.
Thank you, Mr. President. I'm going to give some remarks in 4 or 5 minutes, but I just wanted to encourage the staffers, especially the stenographers, to feel comfortable to keep their distance from United States senators who are delivering remarks. There's no reason, if we have microphones on, to be anywhere near us. So I just encourage them to keep their distance, especially since most members are delivering remarks without masks on. So if there's something that the staff could do to just encourage them to keep their distance, we do want them to be safe. I yield the floor, and I'll be giving remarks in a few minutes.